joining the webinar since we're now broadcasting. Just going to give a few minutes for people to get on. Okay, so it's about 2:01. I'm sure people will continue to join, but we're going to get started in the interest of time. Good afternoon, everyone who's joined us, and thank you so much. My name is Kate Bolton. I'm a staff attorney at the Center for HIV Law and Policy. This webinar is co-sponsored by HIV Modernization Movement Indiana, the Georgia Coalition to End HIV Criminalization, and HIV Prevention Justice Alliance. I'm really honored to introduce the other speakers who will be joining me today on the webinar. Sequoia Ayala is a policy counsel and program manager at Sister Love in Atlanta, Georgia, and is a member of the Georgia Coalition to End HIV Criminalization. Carrie Foote, who has been living with HIV for 30 years, is an associate professor at IUPUI, and she also chairs HIV Modernization Movement Indiana. Sequoia and Carrie will both be sharing their insights and perspectives on reform efforts in their respective states, Georgia and Indiana, after I've talked a bit more generally about the Sourcebook and pathways to HIV criminal law reform. So this is an overview of what I'll be discussing. I'll start with a bit of discussion about the most recent edition of CHLP's Sourcebook on state and federal HIV criminal law and practice, which is a bit of a mouthful. I'll discuss what's new about it and how state advocates can use it to support their work. And after that, I'm going to talk about some of the different pathways to HIV criminal law reform, including some of the potential advantages and disadvantages to those different pathways. And as I said, that will be followed by Sequoia and Carrie discussing the context in their own states, including what some of the thinking has been about choosing a strategic pathway to HIV criminal law reform and some of the factors and considerations influencing that process. The plan is for us to have about 15 minutes at the end for written questions or comments. Through the webinar interface, you can raise your hand to try and submit a question, or you can submit through the chat box feature. And our PITA Panagari will be reviewing and moderating questions at the end and making sure we get to those. So the most recent edition of the Sourcebook was released in August of this year, and it's actually a long-standing project of the Center for HIV Law and Policy. The very first edition was released 7 years ago, and it's something that we've worked to keep current and timely ever since. The Sourcebook contains all state and federal HIV criminal laws in the United States, as well as the US territories. And in this latest edition, we've actually added extensive new content, which I'm going to explain in a little more detail momentarily. But before I get to that, I wanted to touch very quickly on what HIV criminalization is, in case there are folks in attendance who are a little newer to the issue. This will be very fast, just to sort of give a little context. But in a nutshell, as most of us know, HIV criminalization is the prosecution and imprisonment of people living with HIV for things that would otherwise be perfectly legal or are only minor crimes for someone who is not tested positive. So over 30 states and several US territories have HIV criminal laws, including sentence enhancements for sex workers or for underlying sex crimes. There is, of course, a lot of variation from state to state in terms of what these laws look like, but there are some common threads across the board that we can identify. First, the laws primarily target two kinds of behavior: consensual sexual activities that happen without prior disclosure of HIV status are criminalized. This can include vaginal, anal, or oral sex, but is often defined to include activities that pose negligible or no risk of HIV transmission, such as oral sex or sex with a condom or sexual ineffective therapy. The second type of behavior that is targeted is spitting, biting, or other modes of exposure to bodily fluids. And oftentimes this will be specific to law enforcement or correctional officers. On top of these HIV-specific provisions, people living with HIV can be targeted under general criminal laws, such as aggravated assault or reckless endangerment. Across the board, as a general rule, these laws do not require an intent to harm, nor do they require transmission for prosecution to happen. They also tend to be published very harshly as felonies and can require sex offender registration as well. So this map just visually depicts what I've just been describing. We see that there are HIV-specific criminal laws across the United States, and we also see that prosecutions are happening all the time. There have been over 300 prosecutions or arrests since 2008. So, as I said a few minutes ago, the Sourcebook comprehensively catalogs and analyzes all state and federal HIV criminal laws. And in this respect, it is the only resource of its kind that fills that role. The Sourcebook also provides examples of recent prosecutions under these laws and explains important case law and legal precedent. So for instance, has the law in your state been constitutionally challenged, and what was the result of the challenge? In addition to HIV-specific criminal laws, the Sourcebook describes the range of public health statutes and regulations that can be used to impose penalties or other kinds of restrictions on HIV and other STIs. And finally, the Sourcebook describes provisions that enable states to impose mandatory testing or medical treatment under certain circumstances, for instance, if you're arrested for particular kinds of crimes. And we also go over state isolation and quarantine schemes. And what's important to understand about all of these laws across these different areas is that they can or have been used to target people living with HIV or other stigmatized health conditions. And they've also been used to target populations that typically bear a disproportionate burden of HIV, for instance, folks in the sex trade. All of that is to say that the Sourcebook contains everything you need to know to sort of start planning your state reform strategy and getting a sense of the legal landscape and what prosecutions have looked like in your state. And this just shows you sort of the layout of the Sourcebook. Each state has an explanation section followed by the actual text of the law. And on our website, you can access the section specific to your state if you only want to be looking at your state, or you can access the resource as a whole, which covers, as I said, all state and federal HIV criminal law. So in terms of how advocates can use the Sourcebook, one overarching theme to highlight is the importance of legal literacy and learning the law in your state. And I say that for a few reasons. First, it's really helpful if you're comfortable in describing the ins and outs of the law to a variety of audiences. It increases your credibility as an advocate, and it also increases your ability to act as a resource and educator for others who are new to the issue. Another key factor to be aware of is that many states have HIV criminal laws that go beyond non-disclosure of status prior to consensual sex. So, as I said, many states also criminalize things like sex work while engaging in sex work while living with HIV, or sharing syringes while living with HIV, and also things like donating blood. So being aware of these other statutes that go beyond non-disclosure ensures that you can develop a comprehensive strategy that is addressing all of the different ways that people living with HIV are discriminated against and unjustly targeted for arrest and prosecution in your state. As a related point, the particulars of the law are essential to shaping your strategy and your approach to reform. And this is something that I'll talk a bit more about in a few minutes, and when I talk about the different pathways to HIV criminal law reform. Finally, learning how to read the law in your state can be very empowering. We all know that legal language is notorious for its inaccessibility, but of course, lawyers are not the only ones who make change happen. And so a major theme and goal of the Sourcebook is that anyone can use it wherever you are to support your efforts at HIV criminal law reform. In terms of specific ways that advocates can use the Sourcebook to support their work, I've listed some examples on this slide. This is by no means exhaustive, but the Sourcebook can be a great tool for resource creation. For instance, palm cards or fact sheets that you can distribute to educate the public and other audiences about the law in the state. Because it's comprehensive and covers every single state, you can also use the Sourcebook to compare your law to other states' laws. Oftentimes, this is a question that legislators or other policymakers may have when they're first learning about this issue. They'll ask, how do we measure up to other states? And that's a question that you can answer based on this sort of reflected in the Sourcebook. Because we try and provide an example of recent prosecutions that have happened in each state, it's usually possible to get a sense of what the media coverage has been. If you look at those recent prosecutions, you can see if the coverage has been very stigmatizing or sensational, and you can also identify some of the journalists who may have HIV criminalization on their beat and who it makes sense to reach out to potentially for education. And finally, for lawyers, the Sourcebook can be an invaluable resource to review how courts have interpreted the law in your particular state and what the challenges have been, if any. I'm going to spend the remainder of my time discussing the major options for HIV criminal law reform. Obviously, the laws differ from state to state, and a strategy that is wildly successful in one setting may be a non-starter somewhere else. There's no one-size-fits-all model. But that said, we can identify what some of the major options are, along with some of the most relevant advantages and disadvantages of those different pathways. Put very generally, there are three different options. First, repeal, which means essentially eliminating or undoing the law and not replacing it with anything. The second option is modernization, which can happen in a few different ways. One option is narrowing an existing law by adding things like intent to harm, transmission, and using a misdemeanor penalty rather than a felony. Another option for modernization is shifting to a public health enforcement framework where HIV is not treated any differently than other infectious conditions under a state's public health scheme. And I'll note that the term modernization was chosen deliberately. The idea was to build on the Centers for Disease Control, using the same term to describe the process of reforming HIV testing laws. And so it reflects this idea that we're bringing the laws in line with the modern science, right? And it can be a very sort of successful and appealing way of framing it to legislators in particular. Third, in a situation where reform is not possible or where a state doesn't actually have an HIV-specific criminal law but uses things like aggravated assault or reckless endangerment to target people living with HIV. An intermediate option may be pushing for policies that limit the ability of prosecutors to pursue those kinds of cases, or working with prosecutors directly to get them to stop bringing these kinds of cases. So when we're talking about HIV criminal law reform, there are a lot of terms that come up over and over again that we don't always have a shared understanding of what they mean. And so this slide contains a list of helpful terms that often pop up. We don't have a lot of time to go through each individual pairing in great detail, but there are a few that I'll emphasize here. So I explained what repeal versus modernization are on the previous slide. Repeal as it relates to decriminalization or modernization is a little different. When people say decriminalization, what they mean is the removal of criminal penalties related to HIV status. And that could happen through repeal, eliminating the law, or it could happen through modernizing the law such that it no longer contains any kind of criminal penalties. Statutes and regulations are really helpful to understand, and usually both are going to be coming up when we're looking at HIV criminal law reform options. A statute is a law that is enacted by a legislative body, meaning a state legislature. In most states, that means the bill will need to pass through two legislative bodies and then be signed by the state's governor in order to become a law. And just as a statute is created by a legislature, it also has to be modified or eliminated using the same process. Regulations, which are also sometimes called rules or administrative laws, are put in place and enforced by state executive agencies, for instance, a state Department of Health or a state Department of Transportation. Regulations are normally created through something called notice and comment rulemaking. And what that means is an agency will publicly release a proposed rule and allow members of the public to review and comment upon it. And this can include more formal procedures like public hearings, which you can attend and testify on how the proposed rule might impact you or your community. And after that process of public feedback, the agency will issue a regulation, normally along with an explanation of why it made the decision that it did and its response to the different concerns raised during that notice and comment phase. And what's important to understand is that regulations still have the force of law, even though they are not enacted by a state legislature. The difference is important, obviously, because it has consequences for your advocacy strategy. So for instance, are you primarily focusing on persuading members of a state legislature or on a state public health agency? And what type of input civil society is going to have can differ between the two options. Another key and related concept is the difference between criminal law versus public health law, or criminal versus civil enforcement mechanisms. So civil enforcement will normally occur through an executive agency and can include a variety of measures or remedies before a court is ever actually involved. For instance, a health officer could issue an order for someone to stop engaging in a particular type of behavior, or a fine could be imposed. And the chief aim of civil enforcement actions, particularly when we're talking about traditional public health control measures like isolation or quarantine, is to manage risk and protect the public health. So typically, a public health restriction of that kind has to be justified as the least restrictive alternative to protect the public health, and it has to be shown to be reasonable. Criminal enforcement means that a prosecutor brings a case against violators of the law, which can result in different kinds of punishment, usually a fine or jail time or both. Incarceration, yes, is intended to protect public safety, but it's also about retribution and deterrence. In order for someone to be convicted and imprisoned, a prosecutor needs to meet the beyond a reasonable doubt standard, which is a little stricter than being required to show that a particular action is reasonable. So essentially what you need to understand is that public health law and criminal law are operating with different aims, rely on different tools, and use different standards to justify restrictive or punitive actions. So now I'm just going to go over the different options that I identified and some of the pros and cons that go along with each. So the first option, repeal, I think carries the main advantage of most clearly and faithfully expressing our condemnation and rejection of these laws, right? So the laws are discriminatory and stigmatizing and have never been justified, not now and not when they were passed. So the sort of corresponding drawback to repeal is that it can sort of leave open this possibility, like I talked about, that prosecutors simply rely on general criminal laws to target people living with HIV instead of a specific HIV law. So using things like aggravated assault or reckless endangerment, it's something we've seen happen in states like Texas, where the specific HIV criminal law was repealed. Modernization by narrowing an existing law. So relative to pushing total repeal, modernization may sound less threatening and be an easier lift with the state legislature. This is particularly true because modernization allows you to focus on harmonizing the law with current scientific evidence, as I was describing earlier. So legislators may find that framing a little more palatable than the argument that the law is discriminatory and was never justified. Because modernization usually will entail a variety of different changes to the law, you retain a lot of flexibility and bargaining power in terms of sort of what you decide to prioritize as a sort of do or die change versus changes that you would hope to see in a perfect world but are willing to negotiate on. The drawbacks in some ways reflect those advantages. So yes, modernizing the law can be an easier lift with a conservative legislature, but it can also suggest that the laws are justified at their core and only require some kind of minor revision to make them just or acceptable. And just as opening the door to a variety of changes can give you a lot of flexibility, it can also open the door to more problematic changes. So for instance, when you point out to legislators that it doesn't make sense to single out HIV for especially harsh treatment under the law, they might respond by leveling up and adding other conditions to a problematic or harmful criminal law. So modernization by shifting to a public health civil enforcement scheme. Moving HIV criminal laws out of the criminal code and into the public health regulatory framework offers several benefits. First, and perhaps most importantly, we're no longer operating in the criminal framework with associated criminal punishment and the collateral consequences of having a criminal record. Second, moving out of the criminal context into the public health framework is destigmatizing and helps push back against the idea that HIV is somehow different from other serious health conditions. You know, just as other STIs and infectious conditions are dealt with through public health, so too should HIV. However, moving to the public health civil enforcement scheme also raises some drawbacks. So first, conceptions of risk are very different between the criminal context and the public health civil enforcement context. In general, public health is going to be concerned with a lower threshold of risk than you would find in a carefully drafted criminal statute. Relatedly, public health rules or regulations are not usually concerned with whether the risk you pose to others is intentional or not. Rather, it's the risk standing on its own that requires some kind of intervention. And finally, the burden of proof and the due process or procedural protections are different between criminal and civil law. Public health civil enforcement usually requires something less strict than proof beyond a reasonable doubt. And so what this means is that there are fewer requirements that the state has to meet in order to argue that it's legally justified in restricting you in some way, basically. The last option, prosecutorial practice, as I said, may make the most sense as an intermediate option for states where reform is a more distant possibility, or where there is no HIV-specific law and prosecutions happen under general criminal laws like reckless endangerment. I think the pros and cons of this option are pretty readily apparent. While it doesn't require legislative or regulatory overhaul, there is still this danger that prosecutions will continue under the general criminal laws. And even if there is a shift, those changes might be less durable. So if the administration changes or the prosecutor changes in a particular district, those advancements could be reversed. So some factors to consider when you're thinking about these different reform strategies and their application to the situation in your state. I think first and foremost, and probably the most obvious, is the political climate. So what is the composition of your state legislature? Has the state legislature acted in the past several years on other topics that might be considered bellwether issues, for instance, safe syringe access? In addition to the composition of the legislature, I think it's important to figure out the stance of state public health officials and prosecutors in your state. So are they aware of HIV criminalization? Is it something you feel you could make headway on with the right education materials? How do the state legislature or your governor react to the recommendations and expertise of state public health officials? Do they show a lot of deference to recommendations made by public health officials, or not so much? Who are the important stakeholders that you really need to help move the agenda forward? In addition to the authority and influence that state public health has, I think you should consider the current public health regulatory scheme. So are state public health officials routinely engaging in restrictive measures in response to infectious diseases? And what does that process look like? Are there lots of protections and different steps that the state has to take in order to do that, or not? And finally, I think public attitudes can be key and can influence the kind of strategy you ultimately go with. For instance, in a state with a hostile legislature or regressive public attitudes, a campaign that is less visible may have a greater chance of success. And I just want to close with one final comment, which is that this portion of the webinar has obviously touched on a really wide range of important concepts, many of which could be the topic of a standalone webinar or some other specific resource. So CHLP and its partners are in the process of creating some resources related to these issues, for instance, a fact sheet on criminal intent. But we'd love to hear your feedback on what else would be helpful and what would benefit from further discussion, whether in the form of additional webinars or in the form of more targeted resources. So you can submit feedback either to me directly or through the question feature of this webinar. And with that, I'll close, and we'll hear now from Sequoia and Carrie about how these considerations have played out in their states. And I leave it now to them. I think Sequoia is going to be sharing her screen momentarily.
Yes. Hello, hello. Yes, I am getting my screen together. Let's see. Desktop. Okay, can you just confirm that you can see the screen, or that folks can see the screen?
I can see your screen. Yep, looks good.
Okay, perfect. So hello, everyone. Again, my name is Sequoia Ayala. I am Policy Counsel and the Advocacy Program Manager here at Sister Love, a community-based organization in Atlanta. And in my capacity, I also work within the Georgia Coalition to End HIV Criminalization. The Georgia Coalition is a broad-based coalition of both individuals and organizations working across movements to bring an end to the criminalization of people living with HIV. And so I've included the information for folks to look at our website. And this website includes several materials that we put together, one being about a short policy brief that looks in detail at the situation of how folks are criminalized in Georgia and the coalition's perspective on how change should be enacted, as well as a 2-page fact sheet, visual fact sheet that can easily be shared with folks in the community, also with legislators, and that's pretty easy to navigate and read. And for questions or if you want to talk more offline about the work that we're doing, feel free to email me directly, or you can also use the email address that goes to the coalition, which is nhivcrimegeorgia@gmail.com. So to talk to you a little bit about today about our strategy in Georgia, I want to give you a brief history of how our coalition came together. And it really started nearly 5 years ago in 2013 with a group of dedicated activists who sought to examine the effect of Georgia's HIV-specific criminal law and how folks in Georgia were either at risk of prosecution or were being prosecuted and incarcerated under this specific statute. Something that was really important to us in really putting together this coalition was maintaining a focus on the meaningful involvement of people living with HIV and AIDS and really involving the community in the change-making process. And right now the coalition operates throughout the state, although a bulk of our efforts are concentrated within the Atlanta metro area, just by way of how our population is centralized in the state of Georgia. But we do have a number of actors who dedicate their time and their perspective with respect to the folks who are living in our rural communities who are also impacted by this law. And so some of the different activities that we do is that we conduct educational trainings for a variety of different stakeholders, be it public health professionals, state agencies, community-based organizations like Sister Love, or even within AIDS service organizations. And the primary goal or ask when we're conducting those educational trainings is to ask folks to apply and influence anti-stigma, an anti-stigma intersectional lens to the work. And so in addition to that community educational model, we have we as a coalition decided around late 2016 to shift to try to achieve legislative change. And that conversation really came about after about 3 years of of people dedicating their time and efforts to this topic. And there was really some tension around what the next step should be, whether we felt we had made enough progress in terms of community education, really working to undo a lot of the myths and ignorance around the topic of HIV in general, and then to bring up the conversation around criminalization. So to give you a little bit of background about what's going on in Georgia as a state, within the state, Republicans hold a supermajority in Georgia, meaning the governor, the state house, and the state senate are dominated by the Republican Party. And that's not to say that we don't have bipartisan bills, or that that conservative lawmakers are just categorically opposed to the type of reform that we're seeking. Excuse me. Currently, there's just little political incentive or requirement for there to be any sort of bipartisan efforts on not just HIV criminalization as a reproductive justice issue, but a myriad of issues that are related to the ways in which people fully live their lives. So in 2016, we were successful in having a resolution introduced, resolutions introduced both in the State House and the State Senate. And sort of our thinking on that was that we wanted to kind of take things slow. So instead of, for example, introducing a reform bill, we decided that by instead introducing the resolutions, that would give an opportunity for there to be some robust discussion and presentations amongst legislators, and also to find a way to build support around what the ultimate goal would be, which is to introduce a reform bill. So in the State House, HR 240 was sponsored by Sharon Cooper, a Republican representative who also chairs the the Health and Human Services Committee of the State House. And we had a Senate version that was sponsored by Democratic State Senator Vincent Fort. And at the time, the State Senate resolution was introduced too late, and so it died in committee. And with the House version, we were actually able to have it pass through committee. And now we are at a point where a study committee has been assembled, and they are meeting on October 17th to discuss how HIV specific criminal laws impact and act as a barrier to care for folks in the state of Georgia. And so the study committee is comprised of both legislators who are part of the Health and Human Services Committee. There's also there's a doctor or a medical doctor representative from the infectious disease community, as well as other medical practices, because the House resolution was a little bit more expansive, and it looked beyond HIV criminalization, but also looked at barriers to, for example, other chronic diseases like asthma. And so the study committee, after meeting on October 17th, so there was a great emphasis on values building, how we were going to work together to define what our next step should be as a coalition, and really look to define and hone down what individual and organizational commitments look like going forward. Some of the other things that talk about how we got to a decision to even want to introduce legislation was, again, this overwhelming sense of anxiety regarding what do we do now? 3 years of meeting, as folks can know, particularly from community folks who are dedicating their time and donating their efforts to this cause. There was discourse around what the next step should be. And so some folks were adamant that community education was the route that we needed to take to sort of attack this issue. There were other folks who thought engaging prosecutors and asking them to use prosecutorial discretion was the more favorable route. And then lastly, there was discussion around advancing legislative change. And from what I told you about our history, the legislative action was decided to be the favorable course at the time, because there were the folks who were most involved in the coalition really dedicated their time and were committed to making sure that what needed to be done in order to advance legislative action would happen. So how did we get to the conversation around modernization versus repeal? And there was definitely, as Kate alluded to, in sort of what sort of factors you have to weigh when making that decision. We thought we had to definitely take into account the political climate in Georgia. specifically a state that is generally pro-criminalization, pro-incarceration, having some of the highest incarceration rates in the state, and understanding that criminal justice reform strategy would not necessarily gather us a lot of friends and allies in the state House and Senate. However, with the, for example, there were already well-established relationships on the part of some organizational members to the coalition with conservative lawmakers who had a commitment to public health. And so by going the public health route, we thought that modernizing the bill in a way that appealed to the science and logic in mind of those folks on the those folks that made up, for example, the Health and Human Services Committee in the State House and others would be the most persuasive of actions. And with the understanding that by doing a complete repeal and not, that would lead, that could possibly leave us open to prosecutors using their discretion to continue to charge people under criminal laws. And then also recognizing that without understanding stigma, ignorance, and just general overall negative attitudes towards HIV as an issue, trying to seek a repeal measure would have been very impossible. So those are just a few of the things that we considered when making the decision in Georgia, and we will know relatively soon how this will work. And I'm looking forward to the possible success, but then also meeting with other coalition members to decide how we move forward from there.
Thanks, Sequoia. Hi, everyone. This is our PITA. Just before Carrie starts her presentation, I wanted to let you all know that unfortunately the chat feature through Zoom is malfunctioning, and I'm sure you guys have noticed that you don't even have the option to join a chat. We're really sorry about this, but I think the best way to handle the Q&A after Carrie's presentation is if you raise your hand, I'll see that and I can promote you to panelist, and you can unmute yourself and I'll unmute you and you can ask your question live through the webinar. So I'm really sorry that the chat feature isn't working, but if you raise your hand, I promise we'll get to your question. It looks like we'll have a lot of time. Thanks, and to Carrie.
Can you hear me?
Yep.
Yeah.
You can hear me okay?
I can hear you.
Okay. Okay, hi, this is Carrie. What I'm going to cover in my slides here is just who we are, HMM, how we use the Sourcebook, an overview of our laws here in Indiana, and then I'm going to end with some of our thoughts on past reform in our state. So I am chair of the HIV Modernization Movement. We're a fairly new network that's basically, you can see our mission statement there. We're working to modernize about 5 different laws that criminalize people living with HIV in our state. And then we're also working very closely with our state health department to modernize public policies that are directly linked, public health policies that are directly linked to our law. So all my contact information is at the bottom of the slide here. And then this is a picture of our founding members of HMM when we started back in 2016, right after HIV is Not a Crime 2. We came back to Indiana and we formed our network. We try to be, at least on our leadership, which is very small right now. We started with about 11 folks leading the network. Now we're about 6, but we have about 125 people all together on our network following our work and supporting our efforts. And we do also, similar to Georgia, emphasize the MIPA model, where we want the majority of people leading our effort in our state to be people living with HIV, and that's very, very important to us. So moving on, how we use the Sourcebook here. This is the start of what Indiana looks like in the Sourcebook. Indiana is a little bit long because we have several laws that criminalize people living with HIV. Our group started in 2016, but I personally became interested in this issue of HIV criminalization back in 2012 and around there, 2012, 2013. And at that particular time, one of the very first things I found and I went to as a resource was the second, I believe it was the second edition of at the time, of the Sourcebook, to try to understand, well, what's going on in my state, what's going on in Indiana. So it was incredibly informative because I learned really fast what were some of the problems in Indiana, what were some of the charges, convictions that had occurred in Indiana, and that sort of thing. So since then, whenever anybody in any state tries to find out, well, what's going on in my state, I immediately say you have to look at the Sourcebook. It's an excellent place to start, to get a quick summary overview. It's very easy to understand. And so since then, I've continued to use it in different ways. When somebody joins our network, I usually recommend look at the summary in the Sourcebook because it's done very well in our state, and I recommend that in other states. But some other ways that I use it that I want people to think about, you know, it can be used in so many different ways, I think, to support efforts around criminalization reform. Number one, it is an authoritative document. It's created by, of course, the Center for Health Law and Policy, and everybody, you know, who works for them, who puts input into this Sourcebook, they all have professional degrees, which people are going to give legitimacy to. So when you say you cite something in the Sourcebook, people will treat it as a peer-reviewed document. They'll treat it as something that is authoritative, as opposed to, you know, you just saying, well, I know of a particular case and my friend. No, that's not going to do it. People won't take you that seriously, but they will put value into the Sourcebook precisely because of the people who put the Sourcebook together. It's an authoritative document. I would encourage, when you look at the Sourcebook and this new edition, which I think is incredibly well done, it is expansive. Read the introduction. There's some very, you know, I learned something new this time when I read the introduction, just some things that I wasn't too familiar with, such as different approaches to reform and that sort of thing. And then also, other things that can be very useful is the codes in different states, and I know for sure in Indiana, are incredibly confusing to understand at times. They're often not very well written, but because of the legal background of CHLP, they're able to translate that into a language that we on the ground as advocates can understand. So that is also very helpful. Sometimes you can learn, you know, that there's inconsistencies in your codes. Indiana has them. The case examples are incredibly useful. One way we're currently using some of the case examples that are shown in the Sourcebook is to create a database for Indiana. So when you see, if you look at your screen here, there's all these bullets where my mouse is moving. So those are different cases. So what we've done is we've done searches for those cases in our database. We have a public database where you can find most of these, you can find articles, and then we go into those and we pull socio-demographics of the people being charged. What do they look like? Who are they? Is there any kind of disproportionate impact based on race, age, any other thing we might be able to understand from looking at those cases in detail? So you can pull those cases to create a nice little database to kind of show what's going on in your state in terms of how these laws are put into practice and who's most disproportionately impacted from the laws. The new sections I found very useful in this Sourcebook, both in the state sections by now adding some of the more public health restrictive codes is very useful. There's a new federal section that's been added that I found very useful, and I learned something. I had no idea that we had a federal code that made it illegal to donate blood at the federal level. And it may not even impact what you do in your state, but it's good to know that because I've already had somebody tell me, well, you can't change your state blood law because there's a federal law, so Indiana will never change. So then I need to know how to craft an argument to kind of basically explain to them why we can still change our laws. So it's just good to know what's out there. I would highly encourage you, I'm just going to go to another page, you know, read the footnotes. Footnotes in legal documents are incredibly helpful. They go into sometimes more detail. They explain things that I found are incredibly useful. So a lot of times people will glance over the footnotes, particularly I'm coming from the social sciences, and it's like, nah, I'm not going to read that. But you want to read them in legal documents, reports like these, because often there's some incredibly useful information in those footnotes throughout for your particular state. The other way I've used it also is sometimes I get calls from other states that don't have advocacy groups, and Kentucky is one. There are no reform groups in Kentucky, but people can be charged there under some of their basic criminal laws. And I've used the Sourcebook then, and I'd say, well, let's see what's happening in Kentucky, and I can look at another state. I often will compare my state to other states to find out, well, how is their disclosure law written versus our disclosure law in our state. You know, I can learn things in terms of language. I can also, you know, count, you know, we can find out, well, how many states have laws that criminalize donating blood products. And, you know, if we find, well, there's only, let's say 20, I don't remember how many there are, I can point out that very few states are doing this. Why is Indiana continuing to do this? So I just wanted to emphasize, I think this resource is incredibly useful, and I sometimes find that people aren't aware that it exists. So I just would encourage folks, you know, now that you know about it, you're learning about it, maybe you already knew about it, if you have a website for your reform group, put it on there as one of the resources, because sometimes other states are going to your state and then they see that and they find information about their state. And then, as Kate pointed out, if you use something from the resource, cite the document, because then other people looking at your fact sheets might discover this resource by looking at your materials that you're producing. So the other thing I just wanted to point out here on this slide for our state is just showing that people living with HIV in our state have been charged under general criminal laws. A person's medical records may be accessed. And this is really important for Indiana, because if you see on the right here, this HIV Care Coordination Duty to Warn form, and that's actually the name of our law. It's called the Duty to Warn Law. It's modeled after mental health care laws and duty to warn laws there. But people living with HIV are required to sign these forms, and often these forms are directly used as evidence to prosecute people in our state, saying, well, you knew about the law because you signed this form. And that would go into medical records because it's part of their case management, medical records, and that sort of thing there. So as an advocate, it's good for me to know when I'm looking at this, you know, what can be done in my state? Can they just come in and take these forms? You know, do they need a subpoena? How does it work? And then even up here where people living with HIV, this is one of the new sections that's been added in this third edition, may be subject to quarantine. And just knowing what our public health codes are in that regards can be useful as we start to think about reform and different pathways to form and that sort of thing. So moving on, here's Indiana. This is what we look like here. We have several different codes that criminalize people living with HIV. The icons kind of sum them up in a nutshell on what they are. But like many states, we have a disclosure law that criminalizes people for non-disclosure prior to both sexual activities and needle sharing activities. It's very broadly worded. Our law also includes hepatitis B. We also have laws that criminalize donation, sale, or transfer of semen, blood, and plasma when HIV positive. And those two laws, you'll see that there are two different codes linked to those laws. There's IC-16 and IC-35. This is also part of, you know, learning legal language. So 16 is our public health code, 35 is our criminal code. So this is interesting. So if you just look at our disclosure law, if we were able to just successfully repeal the criminal code but left the public health code the way it is, that would be a huge improvement in our state. You would still have a misdemeanor charge that's embedded in the IC-16, but it would get rid of the felony charge, which is part of the criminal code, and that is the one that is normally applied to folks when they're accused of violating this particular code. And then we have down at the bottom the battery and malicious mischief by bodily fluid, and that includes sentence enhancement from misdemeanors to felonies when you're HIV positive, if you have tuberculosis, or any of the hepatitis. So we have several different mix of codes and laws in our particular state that we're looking to reform here. And again, we just kind of started this in 2016. Mostly just kind of developing our identity, developing who we are, coming up with common messages, coming up with a common kind of just guiding principles on what we want reform to look like in our state. But those are the laws that we're dealing with and trying to modernize. So paths to reform. So our context in Indiana, it sounds like we're a lot like Georgia. We are also a supermajority Republican in our state. Our codes are a mix of public health codes and criminal codes. So that I think gives us some kind of just different flexibilities in how we kind of think about what we want to do and moving forward. We also have public health policies that are directly linked to our codes. So that also, I think, creates a unique context in Indiana that even though the public health policies now need modernization and they're also very antiquated, we actually may be able to capitalize on those existing public health policies to argue more for really getting rid of some of the laws in our state and arguing we already have these public health mechanisms and programs that maybe can assist people with disclosure and do it in safe ways and not, ways that penalize people. And then our guiding principles, we've kind of taken this from another document that the HIV Law and Policy has produced, that we basically are kind of going into this, that any criminal law that does exist or remain on our books should be based on criminal intent to transmit, conduct likely to transmit, and only include punitive measures that are proportionate to the harm, and then not be specific to HIV and must exclude diseases that are airborne and casually transmitted. And so, again, some of the other unique context in Indiana is because our codes, some of them are just HIV, but then we also have other viruses, bacteria, other things that are criminalized, like the hepatitis, like tuberculosis, and we don't want to see those criminalized either. So when we argue also for HIV criminalization reform, and modernization, we're going to be looking at that, especially for hepatitis, because we are starting to gather some research on people who are criminalized for hepatitis, and we're finding that it's often sentence enhancement with our bodily fluid laws. And then we haven't quite gotten there yet to discover who these people are who are facing these sentence enhancements with hepatitis. I have a strong, because of the high prevalence of hepatitis C and B among people who inject drugs, that we will eventually find a disproportionate impact of that particular law on people who inject drugs. The other thing I should point out in Indiana is really weird that sometimes the prosecutors, the legal folks will choose very different laws to apply to people. So for our disclosure law, we have had that law applied for the traditional non-disclosure cases, and we have also had it applied for people who attempt to donate blood while HIV positive. They often get both charges on them, non-disclosure charge as well as attempting to donate blood while positive. And then we have in one part of our state, people who are charged for non-disclosure, but that law is not applied. Rather, our malicious mischief by bodily fluid law is applied. So we've found that these laws are sometimes applied in very strange ways in our state, and that makes us also to be very careful. Just because, let's say, we were to, let's say, repeal or modernize the disclosure law, people could still be prosecuted under some of these other laws. So that's where you kind of see at the bottom this mixed approach and all these arrows, which I won't really explain them. We're still trying to figure out what's best in our state. We kind of see, well, maybe some of our codes will repeal, some will be modernization, like the sentence enhancement. Just get rid of the sentence enhancement, just eliminate it. That would be modernization. Or decriminalization, going from a felony, let's say, to a misdemeanor. And for some, like our disclosure laws on the right over here, we're seeing it'll probably be maybe a combination of repeal, modernization, decriminalization. So I think that's all I have. And again, if anybody has any specific questions outside the webinar, all my contact information was on that first slide. So thank you. I will end there.
Great. Thanks, Gary, and thanks, Sequoia, for those great presentations and a look inside your state and what the pathway to reform is in your states. If you have a question, you'll see in the top left corner of your screen a button that says raise hand. And so if you raise your hand, I can promote you to panelist and you can say your question out loud. So Diane, you've had your hand raised for a while, so I'll go to you first. Diane?
Oh, I just couldn't hear, but it's good.
Okay, all right. Then Ashley, I'll promote you, and you can go ahead and ask your question.
Hi. Sorry, my thing restarted on me. This is Ashley. Did you say it was a
Yep,
question?
I can hear you.
Okay. It like turned off and then turned back on right as you were saying my name. My question was, it came to mind when I think it was Carrie was saying something about wanting the laws to include intent and likelihood of transmission. And I was wondering, is it
Hey, Ashley, could you speak up? I can't hear you.
sorry, I'm not sure where the mic is on my. I should probably plug in a headphone. But I
That's
don't know where
much
the mic.
better.
Okay. But my question was, is it something that's done in laws, I guess, to reference some kind of outside medical resource? Like if you were to say like it needs to be something that is likely to transmit according to a definition or according to the CDC or the state public health department or something like how do you define that term, likelihood of transmitting in the law? Does anyone know the answer to that?
This is Kate. I can speak to that. I think rather than relying on a very specific individual authority, which can change over time, and also we know sometimes government agencies like the Centers for Disease Control can actually be kind of slow to embrace new information and sort of new conclusions about the evidence, that it's better to go with language like competent medical or epidemiological evidence. So substantial risk of harm or transmission shall be defined by competent medical or epidemiological evidence. And that as a term could also be further defined to reference sort of authoritative bodies and resources, but in the text of the law itself, I think it's better to go with that inclusive definition that won't be confined to any one source in case that source ends up being slow on the uptake or otherwise problematic or unhelpful.
Thank you.
Great. So, Manzana, I'm going to promote you to panelist. It'll rejoin you. And then I will unmute you, and you can go ahead and ask your question.
Okay, can you hear me?
Yes.
Hello, everyone. I'm Manzana of the T, Savannah, Georgia. This is for the young lady of Georgia. We're here in the rural area of Savannah, Georgia. Like you said, only the metro area receives any kind of help from you guys, but y'all do extend to the rural areas. What can we do as a rural area organization, and we also part of Georgia AIDS Coalition? What can we do to join you guys as a coalition to get help here in the rural areas?
Hi, thank you. So I think that in terms of like rural participation in these conversations, I think that, you know, getting on the listserv, if y'all are not on the listserv, is like the first way, because that's how most of our communication, even though most folks are in the metro area, most of it is still via like our Google group, and then via conference calls to try to make it so that as many people as possible can participate. And then, you know, I would say that setting up dates and times where, you know, we can actually meet in person And that may entail the folks from the metro area coming to the rural area. Because I think we have a lot more folks who generally don't do that much traveling outside the metro area, whereas there's such a high demand for folks in the rural area, not only to come here to work with us as allied organizations, but then that's also where the state capital is. And I know how inaccessible that can be for folks.
Okay, well, that's real good. And is there any way you could possibly send me an email link so I can contact you guys for when we are in Atlanta? Because we don't mind traveling.
Okay.
That's not a problem to us.
What was your name again?
It's Manzana, and it's the TLLC, and the email address is teetiacem@gmail.com.
Okay. All right. I got it. And Manzana, I don't know if you
Okay.
remember me, but I think we met before.
Oh, we probably have, because we always take a couple of groups here from the rural area of Savannah to the state capitol to legislate against all laws. So we probably have met before at one of the conferences.
Thank you.
Okay,
Thank
great.
you.
Great. Jeanette, JMO, I just promoted you to panelist and I've unmuted you, so you can go ahead and ask your question.
Okay. The Missouri Prosecutors Association has not in the past been particularly open to letting go of any law that they might prosecute someone under. Is there advice for successfully working with prosecutors that you could offer?
Yeah, I think one strategy that we have found successful in the past is partnering with medical providers as part of that outreach and education to prosecutors. So prosecutors sometimes will view us, as zealots or activists and not be all that open to hearing what we have to say. But if you bring like a medical provider who specializes in HIV into the conversation, and they're the ones who are, giving us sort of HIV 101, and prosecutors are hearing from a medical provider that something like spitting or oral sex really can't transmit HIV. That can be viewed as more credible and be a little more persuasive. So it's something that we've done in our interactions with prosecutors here at CHLP, and it's something that you could do at the state level as well.
Thank you.
This is Carrie. I wanted to point just one other thing about prosecutors. We haven't done this yet, reached out to prosecutors to try to do any kind of educational forums, but we did have a recent conviction here in Indiana where the write-up on that particular conviction in this mentioned prosecutors and how the prosecutors themselves were incredibly frustrated with Indiana HIV criminal laws because they couldn't make sense of them but they really wanted to convict this guy and charge him with all kinds of different things, but they couldn't figure out our laws to do that. And it made me think, what, maybe they want reform too. I mean, we have kind of opposite goals with prosecutors, but who knows, maybe they could actually be an ally in some way to say, what, if we get better laws, they can even do their job better. But of course, we'd be on the other side advocating to make sure that those laws are as fair and as just and as possible as they can be. So I think all of that is to say, maybe keep your eye out when you hear, prosecutor so-and-so or whatever is frustrated. Maybe reach out to them and say, hey, we can educate you. We understand your frustration. We're frustrated too. So that's all I had to add.
Thanks.
All right, thanks, JMO. Nina, I've promoted you to panelist and unmuted you, so you can go ahead and ask your question. Nina?
Yeah, hello. For some reason,
Hi.
it knocks me off. I have two comments. One was for the woman from Savannah who was talking about that she was affiliated with the Georgia AIDS Coalition. I just wanted to let her know that Kathleen Tien from the Georgia AIDS Coalition is in communication with our group, and we normally work in tandem with Georgia AIDS Coalition every year to do that HIV Lobby Day. So I just wanted to put that out there. Secondly, there are public health laws that incorporate like established guidelines for clinical care. So there are laws around, for example, expedited partner therapy for chlamydia and gonorrhea that even in the absence of statutory authority, that they adopt by reference, for example, CDC's 2006 or 2010 or 2015 STD treatment guidelines. And in those jurisdictions, that incorporation of those standard guidelines has the force of law. So I just wanted to make those two comments.
Thanks so much, Nina. For those of you who don't know, Nina is actually an advocate from Georgia, so those comments are really appreciated. If there are any other questions, we have, oh, yep. Manzana, promoting you and unmuting you. Manzana, you can go ahead.
Okay, yes, yeah. I am familiar with Kathleen, and I will get with her because Susan Saylor, who's our Deputy Director of Georgia AIDS Coalition, the TLC is just the form of the Transgender Empowerment Incorporation here in Savannah, Georgia, and we partner with the Georgia AIDS Coalition. But thank you for the advice, and I will get with Kathleen. Thank you so much. I'm really enjoying this webinar. Thank you for inviting me.
Great, thanks, Manzana. George, I've promoted you to panelist and unmuted you. I think you'll be our last question, so go ahead.
Thank you. My name is George. I'm a disability advocate in Denver, Colorado. And my question is more around disclosure. And I know that in some of these cases, the question of disclosure and being able to prove disclosure comes up, sometimes where there have been witnesses or even articles in newspapers about a particular person, there's still a sentence that happens. So I'm wondering if the Center for HIV Law and Policy has any recommendations on disclosure. I know that sometimes it's recommended that we text or email or have some form of written disclosure, but I'm wondering if there is example of perhaps disclosures that actually have held up in court, and what a disclosure really is, and what constitutes disclosure under the law, and does that vary by state also?
Thanks for your question. Yeah, we have sort of general recommendations on some of our resources. I believe we have a palm card which outlines some self-protective measures around disclosure. For instance, saving emails or text exchanges showing that you disclose to someone, taking a partner to your doctor or caseworker's office and asking them to put in their notes that your partner has knowledge of your status, discussing your status in the presence of another third party who can testify to that if you are prosecuted, or recording disclosure, for instance, with your cell phone. So, I mean, those are some general options. Disclosure is very challenging because, typically people are not taking one of those measures. These are normally conversations that are occurring behind closed doors before some sort of intimate contact, and you don't whipping out your phone to say, wait, can I record this conversation? Doesn't exactly like advance the mood, but it's something that could be protective in court. In terms of how disclosure is treated from state to state and whether it's explicitly recognized as a defense or acknowledged specifically at all in the text of the law, that really varies. And same goes, I think, for sort of how disclosure has been understood or recognized with particular fact patterns. So like you mentioned, there are instances where someone has made their disclosure, their status known, for instance, in Facebook, or they've been like profiled in a local newspaper or something, but the partner still claims that they didn't know, and courts have gone along with that, which is really outlandish. But I I don't know that there's a sort of general conclusion I can make about how courts treat it, because there's just variation from state to state. I think those different steps that I described initially would be very helpful, but no guarantee. So that's where I would leave it.
So it sounds then like along with a disclosure, it's almost necessary to have an acknowledgement by the person to whom you're disclosing.
Well, yeah, certainly that's very helpful. I mean, if you have some kind of text or other exchange, email, what have you, where there's disclosure and someone acknowledges that, then that should hold up, you would think, as demonstrating that the person was aware and entered into whatever the conduct was with full knowledge of the situation.
And if I can ask one more final question,
Mm-hmm.
is if a person who is negative says that they are HIV positive, is there any issue that you can imagine with that? And I ask because I have an idea for the bathhouse community, for men who have sex with men in relation to HIV, because a bathhouse usually has a waiver that it's signed before people go in. And it's been my idea that if we can include in the waiver a disclosure and an acknowledgement statement for every member to state that they are HIV positive and or may have been exposed to HIV and other STIs, and then an acknowledgement signed by every member acknowledging that every member has made this disclosure, I'm wondering, because that's one of the few environments that people actually do sign a form before engaging in a sexual activity. I'm wondering if something like that could be used as a protection, as a blanket statement that everyone here says, yes, I'm positive.
That's an interesting question. It's not something that we've encountered. I think that kind of waiver could maybe help you escape like civil liability, but I don't think it would render you totally protected from criminal prosecution. But I'm not completely sure. That would be my expectation. So civil liability meaning someone could sue you and like under a theory of negligence or something like that and say you didn't disclose and you exposed me to harm or you harmed me. But
this is Carrie. I think it can be just hugely problematic if it's going to be part of membership in the bathhouse, because now you're kind of compelling people to disclose their HIV status to join the bathhouse. And I suspect the bathhouse would lose membership. And we tend to not support any kind of compelled HIV disclosure, that should be voluntary. So that's just another thing to think about, in terms of your very creative idea there.
Mm-hmm. I look at that, but I think a lot of times in the bathhouse community, we assume that everybody is positive for something. And it's one of the environments that really promotes the awareness of STIs within the community. I mean, we have testing in our bathhouses, there's posters, there's condoms. So it's not something they shy away from. And again, so if everybody said, I'm HIV positive, and that was just, it's not just only the positive people acknowledge it, but even the negative people come in and say, I'm positive. And this is the reality of engaging in sex in a gay bathhouse. I'm kind of wondering if we can change that mode of thinking.
Yeah, George, that's a great, oh, sorry, go ahead.
Go ahead. No, go ahead, I'm fine.
Yeah, that's a great point, and it's something we point out in our arguments all the time about the need for reform, right? So HIV is sort of treated in this exceptional way relative to other STIs, right? Really, in any sexual partnership, there is risk assumption when you have sex with someone, right? Even if they tell you, I am free of STIs, that could be untrue. It could be untrue because they're not telling you the truth, or it could be untrue because they simply don't know. And people often will report their health status without necessarily having been screened recently enough to really say authoritatively what their situation is. So, I mean, our attitude is very much that you know, responsibility for safe sex goes in both directions, and with respect to HIV or any other STI. And so it's a way of shifting the way we think about HIV relative to other health conditions. So I'm glad you made that point. I agree that it's very important.
Thank you.
Okay, so I think we've reached the end of, you know, our allotted time. Thank you all so much for attending and for putting up with our improvisational Q&A style, and thank you especially to the panelists who presented. Thanks, everyone.